You're walking to your car after dropping your kids off at school. A man in a vest that says police approaches you. He's not a local cop. He asks one question. Are you a citizen? And in the next 10 seconds, what you say determines everything. Not just a ticket, not just a fine. We're talking about detention, removal proceedings, separation from your family. Every day across America, people face this exact moment, and they make the same critical mistake. They answer, they explain, they try to prove themselves. But the law does not reward people who talk their way through an ICE encounter. It rewards people who know exactly what to say and exactly when to stop. I've spent years analyzing immigration enforcement law, studying hundreds of documented ICE encounter cases, and reviewing landmark Supreme Court rulings. I've identified 4 exact phrases that protect you during an ICE encounter. Phrases grounded in the... And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. Constitution of the United States. Miss one and you hand agents legal ammunition to use against you. Use all 4 and you walk away with your rights intact. This is educational content only, not legal advice. For specific guidance on your situation, consult a qualified immigration attorney in your state. Let's break down the 4 mistakes and the 4 exact phrases that protect you. Mistake 1. Answering. Are you a citizen? The mistake. An agent approaches you in public, maybe outside your workplace, maybe on the street, maybe outside a courthouse. He asks the question almost casually. Are you a citizen? Most people answer immediately. Yes, no, I'm a permanent resident. I have a visa, I was born here. Every one of those answers is information, and every piece of information you give can be used against you in immigration proceedings. The scenario. You're outside a grocery store. An ICE agent in plain clothes approaches and identifies himself. Are you a citizen? You say, no, but I have papers. He follows up, what kind of papers? You explain. He asks where you were born. You tell him. He asks when you came to the United States. You answer. 20 minutes later, you are in the back of a vehicle because the answers you voluntarily gave created a trail that justified further detention. And you never had to say a single word. Why people do it? People think that answering proves innocence, that being cooperative keeps things calm, that admitting to having legal status will end the encounter quickly. But ICE isn't psychology. Agents are trained to ask this question casually and early. It sounds like small talk. It is not. It is the opening of an investigation. The question gets you talking before you realize you are being interrogated. Once you start, it is very difficult to stop. And agents are trained to exploit that momentum. The correct move. Here is line 1. I am choosing to remain silent. That is it. Calm, clear, polite. I am choosing to remain silent. Not rude, not confrontational, just legally protected. If they keep asking, you repeat it. I am choosing to remain silent. Why it works. This explicitly invokes your Fifth Amendment right. You are not ignoring the agent. You are not being aggressive. You are stating a constitutional right out loud, which under established law is the correct way to invoke it. The body camera footage will show a calm person asserting a legal protection. Not some. And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. Someone hiding something. Bottom line, never answer the citizenship question with anything other than this line. Every other answer is evidence. Mistake 2. Opening your door or stepping outside when ICE knocks. The mistake. You hear knocking. Maybe it's early morning. You go to the door. You open it. The moment you open that door, you may have just changed everything, because under established Fourth Amendment law, opening your door to agents can be interpreted as giving consent to their presence. The scenario. ICE agents knock at 6 a.m. You open the door. They say they just want to ask a few questions. You step outside to talk. The moment you step outside, you have left the protection of your home. Or you leave the door open and agents later claim you consented to their entry. Neither of these has to happen. Why people do it? People open the door because someone is knocking. Because it feels rude not to. Because they think they have nothing to hide. But your home is the most protected space in American constitutional law. The Supreme Court ruled in Payton versus New York in 1980 That the government cannot enter a home to make an arrest without a judicial warrant. Your home is your strongest legal shield, but only as long as you do not give up that protection by opening the door. Legal reality. There are two types of warrants in the immigration context, and this distinction is critical. An administrative warrant is a document signed by an ICE supervisor. It is an internal government document. It is not reviewed by any judge. Evidence problem. The critical legal trap here is consent. If you open the door wide and agents walk in, their attorneys will argue in court that you invited them inside. If you step outside and start talking, you have left the space where your constitutional protections are strongest. This can all be avoided with one action. Do not open the door. Agent psychology. Knocking loudly at early hours is a deliberate tactic designed to create disorientation and urgency. Agents know that a disoriented person opens doors. They may also identify themselves as police. ICE agents are federal law enforcement, and the word police on their vest is legal, which increases the psychological pressure to comply. The correct move. Here is line 2. Do not open the door. Speak through it, or through a window, and say, "Do you have a judicial warrant signed by a judge?" Say it through the closed door. You are not being obstructive. You are exercising a constitutional right. If they say yes, they will slide the warrant under the door or hold it up to a window. Check for the words United States District Court at the top and a judge's signature. If it does not have those, it is an administrative warrant, and you are not required to open the door. If they say no, you say, "Then I do not consent to entry. I am invoking my Fourth Amendment rights." Why it works. This puts the legal burden exactly where the Constitution intended it, on the government to produce proper authorization. You have created a clear record of non-consent. If agents enter anyway, your attorney has grounds to challenge everything that follows. Bottom line, never open your door to ICE without first asking for a judicial warrant signed by a judge. Mistake 3, signing anything without an attorney. The mistake. You are detained. An agent places a document in front of you. Maybe it is labeled voluntary departure. Maybe it says something about your case. The agent says it is routine, or that it will help your situation, or that if you just sign, you can go home sooner. Most people sign that they just ended their right to fight their case in immigration court. The scenario. You have been detained. You are scared. An agent tells you that if you sign this document, you will be allowed to, leave in a few days instead of being held longer. The document is a voluntary departure order. You sign it. You have just waived your right to a hearing before an immigration judge, your right to present evidence, your right to challenge the government's case. All of it gone because of one signature. Why people do it? People sign because they are frightened and want the encounter to end. Because agents frame the document as routine. Because they do not understand that in immigration law, your signature is legally binding and can permanently affect your ability to remain in or return to the United States. Under the Immigration and Nationality Act, a signed voluntary departure agreement is treated as a legal waiver of your right to a removal hearing. Legal reality. The Fifth Amendment's Due Process Clause, which applies to all persons facing government deprivation of liberty, as the Supreme Court established in Matthews v. Eldridge in 1976, protects your right to a meaningful hearing before an immigration judge. Once you sign away that right, reclaiming it is extraordinarily difficult. Evidence problem? A signed document is the strongest possible evidence against you in immigration proceedings. It requires no witnesses, no body camera footage, no testimony. Your signature is treated as proof of knowing and voluntary agreement. Even if you were frightened, even if you did not fully understand, courts generally uphold signed immigration documents. Agent psychology. Agents are trained to present voluntary departure as a benefit to you. Faster processing, going home sooner, less time detained. What they do not explain is that a voluntary departure can bar you from returning to the United States for up to 10 years under current immigration law, and that signing waives a hearing where you might have valid defenses. The correct move. Here is line 3. I do not sign anything without speaking to my attorney. Say it every single time a document is placed in front of you. I do not sign anything without speaking to my attorney, even if you do not currently have an attorney. Under the Immigration and Nationality Act, you have the right to be represented by counsel in removal proceedings, though the government is not required to pay for one. You must invoke that right by saying, I want to speak with an attorney before signing anything. Why it works. This creates an unambiguous legal record that you requested counsel. And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. It's the signing process, and it gives you time, which in immigration proceedings is the most valuable asset you have. Bottom line, never sign a single document during or after an ICE encounter without first consulting an attorney. Not one. Mistake 4, not asking, am I being detained? The mistake. An agent is asking you questions. You are answering because you feel like you have to, because he is standing right there, because it feels like you cannot leave. But are you actually detained, or are you free to walk away right now? Most people never ask. And that silence, that failure to clarify your legal status in the encounter, is one of the most costly mistakes you can make. The scenario. You are stopped on the street. An agent asks where you are going. You answer. He asks where you are coming from. You answer. He asks for your name. You give it. He runs your name and finds something, an old address, a name similarity, something in a database error. Now the encounter has escalated. But here's the thing. At the beginning of this encounter, you may have been legally free to walk away. And you never asked why people do it. People assume that because an authority figure is standing in front of them asking questions, they must answer and must stay. But the Supreme Court established in Terry versus Ohio in 1968 that there is a critical legal distinction between a consensual encounter, where you are free to leave, and a detention, where the agent has reasonable suspicion of a specific violation and is legally holding you. In a consensual encounter, you have the full right to leave. In a detention, you have the right to know why you are being held. Legal reality. Under INS versus Delgado, decided by the Supreme Court in 1984, questioning alone does not constitute a detention. Officers can ask questions in public, but if a reasonable person would not feel free to leave because of the number of agents, physical blocking, or direct commands, then a detention has occurred, and it must be justified by reasonable suspicion. The critical word is articulable. Agents must be able to point to specific facts, not race, not accent, not appearance alone, that support reasonable suspicion of an immigration violation. In Gonzalez versus ICE, a federal court ruled that ICE violates the Fourth Amendment when it detains people without individualized probable cause. Evidence problem. If you never ask whether you are detained and you simply stand there answering questions, a court will almost certainly treat the entire encounter as voluntary. That means everything you said was given freely. That means the agent was not required to have any suspicion to keep talking to you. By never asserting your right to leave, you may have converted a potentially unlawful detention into a voluntary conversation. On video. Agent psychology. Agents rely on what legal scholars call the compliance effect. When people see a badge and a vest, they stop. They answer. They wait to be dismissed. Agents are trained to exploit this reflex. They do not tell you that you are free to leave because they are hoping you will not ask. The correct move. Here's line 4. Am I being detained or am I free to go? Ask it directly and calmly. Am I being detained or am I free to go? If the answer is no, you are not detained, then say, "Thank you, officer," and walk away. Do not run. Do not explain. Do not give one more word. Walk away. If the answer is yes, you are being detained, then immediately return to lines 1, 2, and 3. I am choosing to remain silent. I do not consent to searches. I want to speak with an attorney. Why it works. This question forces the agent to make a legal decision on camera. If he says you are free to go and you leave, the encounter is over. If he says you are detained without being able to articulate a specific legal basis, your attorney now has evidence of an unlawful detention, which can affect everything that follows, including suppression of any evidence gathered. Bottom line, always ask whether you are being detained. Do not assume. Do not wait. Ask. Here are the 4 lines one more time. Write these down. Put them somewhere accessible. Practice them until they are automatic. Line 1, I am choosing to remain silent. Use this immediately when asked about your citizenship, your birthplace, or your immigration status. Line 2, do you have a judicial warrant signed by a judge? Use this before opening your Door to anyone who identifies as immigration enforcement. Line 3. I do not sign anything without speaking to my attorney. Use this every single time any document is placed in front of you during or after an encounter. Line 4. Am I being detained or am I free to go? Use this to clarify your legal status the moment you are unsure whether you must stay. 4 lines. That is it. Stay calm, stay polite. Do not run, do not resist physically, but do not give away rights the Constitution guarantees you. One critical final point. These rights belong to every person in the United States. The Fifth Amendment says no person shall be deprived of liberty without due process of law. Not no citizen. No person. The 14th Amendment guarantees equal protection to any person within the jurisdiction of the United States. The Supreme Court has confirmed this repeatedly. You do not have to be a citizen for the Constitution to protect you. You just have to know how to invoke those protections correctly. This is educational content only. It is not legal advice. For guidance specific to your situation, consult a qualified immigrant. And if you like the video, please don't forget to leave a like, subscribe to the channel, and turn on the notifications bell. Immigration attorney immediately. If you found this valuable, hit the like button. Subscribe for more legal breakdowns on your constitutional rights. Share this with everyone you know, because the people who need this information most are often the people who have never seen a video like this one. The smartest people in an ICE encounter are not the ones who talk their way through it. They are the ones who know exactly what to say, exactly when to say it, and exactly when to stop talking entirely.